And this bill would restore the law to how it existed for decades prior to the technical drafting era that occurred late in the legislative session last year. And we truly feel that this is the best way to inform the public about notices. And bear in mind that these notices are not intended to reach buyers. They're intended to deputize the public to notify individuals in the community who would be affected by this very public event where they're being separated from their personal property. And this is designed to reach that community in the best way possible, and we respectfully ask for your aye vote.
Thank you very much. Are there other witnesses here in support of Senator Emerson's measure? Are the witnesses here in opposition to the senator's measure?
Move the matter.
The matter has been moved, but it can't happen yet, guys, because we have to establish a quorum first, which is now here. Let's call the roll.
Fuhrer.
Here.
Wagner.
Here.
Atkins. Here. Dickinson. Here. Gaines. Huber. Here. Huffman. Jones. Monning. Here. Wykowski. Here.
A quorum's been established. Now entertain a motion on the bill.
I'll move the matter, Mr. Chair.
It's been moved and seconded. Are there questions, colleagues, for Senator Emerson? Comments? Seeing none, Senator, would you like to close?
I just asked for an aye vote. Thank you.
Very well. Please call the roll.
Fuhrer.
Aye.
Fuhrer, aye. Wagner.
Aye.
Wagner, aye. Atkins. Atkins, aye. Dickinson. Gaines. Gaines, aye. Huber.
Aye.
Huber, aye. Huffman. Jones. Monning.
Aye.
Monning, aye. Wykowski.
Aye.
Wykowski, aye.
Matter's approved. Congratulations, Senator. Very good. So we have a consent calendar. Is there a motion on the consent calendar, please? Is there a second? And again, I want to point out for colleagues who didn't arrive when I made this announcement initially, Senator Rubio's item SB 110, item number 10 on the consent calendar, has been pulled from the consent calendar for today. So having said that, call the roll, please.
Fuhrer.
Aye.
Fuhrer, aye. Wagner.
Aye.
Wagner, aye. Atkins. Atkins, aye. Dickinson. Dickinson, aye. Gaines. Gaines, aye. Huber.
Aye.
Huber, aye. Huffman. Jones. Monning.
Aye.
Monning, aye. Wykowski. Wykowski, aye.
All right, that's been approved. Now, I understand we have 1, 2, 3, 4, 5 additional senators whose bills are before us. I understand from the sergeant that each of those senators purportedly is on the way. So I will take them at their word and assume we'll be hearing from one of them imminently. In the meantime, we will just relax for a second. Not going to recess. We'll just be here for a moment and we'll see. I did welcome in absentia our colleague, Ms. Gaines, who is serving in lieu of Mr. Gorell for the balance of this term. And now that you're here, I want to formally welcome you to the committee. I will announce it's now 11:15. If no senator is here to present bills, oh, Ms. Woke, you came just in time. Just in time. All right. Senator, I was going to adjourn. All right, so Senator Woke is here on item number 3, SB 154. Senator, always a pleasure to have you here. Good morning.
Pleasure to be here. Thank you, Mr. Chair. Members, 154 will eliminate the sunset date and requires a follow-up report no later than July 1st, 2014. The bill will allow Solano County to continue collecting a fee on marriage licenses and copies of vital records to support domestic violence prevention and intervention services for victims and children. Several counties and cities are already authorized to collect fees for this purpose, some on a permanent basis. The county deposits these fees into a fund that is currently being used for the Solano County Family Justice Center. Eliminating the sunset date will provide greater opportunities for this Justice Center to leverage other funds. Domestic violence prevention services are very important to families in need. Solano County has built a very impressive consortium, which we need these days, pull everybody together, to provide services to residents. This will allow them to continue their efforts. I have with me Carolyn Wold, Director of the Family Justice Center in Solano, to testify in support. And I ask for your aye vote.
Thank you very much. Senator, your first witness, please.
Good morning. Carolyn Wold, Office of Family Violence Prevention and Director of the Solano Family Justice Center. The vital records fees that we've been able to collect in the past have allowed us in 2010 to draw down over $950,000 for our Family Justice Center efforts. In 2007, 2008, and 2009, Solano County had about 2 domestic violence deaths. In 2010, as we were beginning to launch our Family Justice Center, we had 21. These funds are vitally important to our work in trying to eliminate these deaths, to reduce children's exposure to violence, and to addressing violence before it ends in homicide. So please, I urge your aye vote on this.
Thank you for your testimony. Next witness in support.
Mr. Chairman, other members, Paul Yoder on behalf of the Solano County Board of Supervisors, the sponsor of the bill. I'm just carrying Carolyn's briefcase today. I would urge your aye vote. Thank you.
Very good. If she had a briefcase, I'm sure it would have been carried well. Are there other witnesses in support of Senator Woke's legislation? Witnesses in opposition to the bill?
Mr. Chairman, members, good morning. David Wolf here with the Howard Jarvis Taxpayers Association. We're in opposition to the bill, primarily on Proposition 26 grounds. Proposition 26 was a proposition approved by voters in November that get closer, there we go. A 2/3 vote for various taxes and fees, both on the state and the local level, and we do believe this bill needs to have a 2/3 vote on the county level in order for it to move forward, and we're opposed primarily on those grounds. Just want to run through the exemptions. Prop 26 listed a number of exemptions that would make this a regulatory fee as opposed to a tax, and just want to discuss a couple of those. Really, there's only one that's even debatable that could make it a regulatory fee, and that is simply that Article 13C, Section 1 says a charge imposed for the reasonable regulatory costs to a local government for issuing licenses and permits, performing investigations and inspections, and so on. We believe this exemption is flawed, and this requires a 2/3 vote and is a special tax for 2 reasons. Number one, there's no nexus between marriage license fees and domestic violence. This is one of the issues we've had with these Sinclair paint fees over the 20 years since that case was established by the California Supreme Court. And secondly, local governments simply do not regulate marriages in any form, and as such, this is not a regulatory fee and again requires a 2/3 vote. So for those reasons, we'd ask for your no vote. Thank you.
Thank you for your testimony. Other witnesses in opposition to the bill? Seeing none, I have a question, Senator. Senator, isn't it the case that all we're doing today is authorizing a local jurisdiction to seek to continue to have an increase in fee, and it would be for the local jurisdiction to determine whether or not it needs to comply with Prop 26?
That is correct.
Okay, thank you. Other questions or comments for Ms. Atkins, followed by Mr. Wachowski?
I would just move the bill, Mr. Chair.
Bill's been moved. Second. It's been seconded. Mr. Wachowski.
I was just wondering, and I don't know if you know the answer, is that when this pilot project was set up, why there wasn't legislation or why it wasn't expanded to all the counties. It seems like I'm from Alameda County, and I see how it went Solano County, and then it went Stanislaus County. Why? Because now I know that we have Prop 26, which makes it problematic, but I was curious.
I can only.
Yeah, I would just say, Senator Evans last legislative session had a bill, and it stalled, and there were reasons for it stalling, and maybe I could come back and talk to you and your staff before I just sort of out the opposition to that bill, but gratuitously. But yeah, there have been bills just last session to extend this to all counties, but that measure didn't get down to the governor.
This will be the first time in this committee that someone has chosen not to gratuitously impugn their argument. Okay, are there others with questions or comments for Senator Woke? Oh, Mr. Wagner.
Real quick, actually, it's not for Senator Wolk, maybe for Mr. Wolf. If you could address the concerns raised by the chair that this isn't an end run around Prop 26, it's just an authorization for the locals to impose a fee. Your assessment of that point.
Mr. Wagner, it's a good question. Thank you, sir. We do believe that, and I think the committee analysis backs this up, that this is an authorization, and thus the two-thirds vote required by Prop 26 would only be on the local level. But to the extent that this does impose a fee without a nexus, we've been opposed to these things for a number of years, and for the sake of consistency, we must remain opposed to this as well. Thank you.
Thank you, Mr. Wagner. Again, I think it's a fair summation of where we are on the critique that's been offered, that the action of this legislature does not implicate Prop 26, that there may be implications for the locals. It's up to the locals to make that determination. It's a local control bill, isn't it, Ms. Wilk?
Indeed.
All right. All right. Would you like to close?
Briefly, we would like to join Alameda, Sonoma, Contra Costa, and Stanislaus in continuing this program. I've been the queen of sales tax and other extensions statewide, design build, for example. We've started out over the past 6 years, 7 years, 8 years, slowly with one county, with 2 counties, with 3 counties, and then statewide, but it's always very difficult to do that. So in this particular case, we have a program. We want to continue it. Time to get rid of the sunset like others. I ask for your aye vote.
Call the roll, please.
Fear?
Aye.
Fear, aye. Wagner?
No.
Wagner, no. Atkins? Atkins, aye. Dickinson?
Aye.
Dickinson, aye. Gaines? Gaines, no. Huber?
No.
Huber, no. Huffman? Jones?
No.
Jones, no. Monning?
Aye.
Monning, aye. Wachowski?
Aye.
Wachowski, aye.
That bill has 5 votes and needs 1 more. It's on call. Senator, thank you very much. All right, now we'll turn to Mr. Simidian, who is next in line, to be followed by Ms. Keogh if she's here, and if not, by Mr. Padilla. Senator Simidian, good morning.
Thank you, Mr. Chair and members. Let me begin by accepting the following changes as author's amendments on page 5, lines 6 through 7. We have agreed to replace, quote, Office of the State Chief Information Officer, end quote, with California Technology Agency, end quote, to reflect the recent name changes discussed on page 4 of your analysis. And we would also like to add Senator Fuller as a co-author on the bill as we're making these amendments. Members, a little bit of history, both on how we got here and why I think it's time to move forward. Back in 2002, then Senator Steve Peace and I, then Assembly Member Joe Simidian, authored a pair of bills that established the first data breach law in the United States. And the data breach law essentially said, if you're going to lose somebody's data, you should tell them, give them notice. So this was a data breach notice bill. Today it seems like no big deal. At the time it was a fairly big deal. And 40-plus other states around the country copied California's law, and it set the standard for what is today the custom and practice around the country, which is You've got somebody's data and you lose it, then you have to tell them. That's a good thing for at least a couple of reasons. First and foremost, because if you tell people that their data has been compromised, they can take some steps to protect themselves. If they don't have the information, obviously they can't protect themselves. Not coincidentally, it's also a good thing because once people realized they were going to have to tell the world, hey, we lost your data, they started to work a little harder not to lose your data. And so data security efforts over the past decade have stepped up as well. Now that we've had the chance to look at more than 40 other states around the country and see how they've handled it, at least a half a dozen or more have, probably a dozen at this point, have taken what they consider the next logical step. And I think they are right. And the next logical step is to say, could we be a little clearer about what we'd like to see in the notice? And the research that we've seen suggests that while probably many of the notices that people get when there's been a security breach are relatively helpful, a number of them, frankly, are anywhere from entirely unhelpful to altogether confusing for one very simple reason. We did not put in the original law back in 2002 any specific requirement about what the notice of the breach had to require. The goal was to provide as much flexibility as possible. I still think that was a wise judgment, but here we are a decade later, and we hear from both businesses and consumers that it would be helpful if there was more clarity and specificity about, well, what happened. So what this bill does is it simply amends existing California state law, drawing on the experience of other states, and it says when you get that letter in the mail that says, hey, we lost your data, it would be helpful for you to know when did it get lost, what got lost, how many data files got lost, and by the way, who do I call if there's something to do about the problem. A side provision, just because it's important, I think, to note, requires that where there are more than 400 individual data files that have been compromised, an electronic record would come to the state of California so that over time, law enforcement has the ability to assess big picture statewide, where is the problem developing? Is it particular kinds of accounts or particular kinds of systems? When is the problem happening? Are there particular times of day when systems are deemed to be more vulnerable? How are these accounts being accessed? Is it as silly and simple as people leaving their laptop on the top of their desk while they walk out the door with 50,000 data files sitting there in their laptop, or is it more sophisticated? That's information that would be helpful to have not only for law enforcement but also for subsequent legislation so that we could do a better job here in addressing the problem legislatively. The bill has a long and storied history in your committee, Mr. Chairman. This is its fourth year. The first year, then Assemblymember Jones, very different from this Assemblymember Jones, had a bill that he wanted my bill tied to. Well, apart from their obvious thoughtfulness and consideration, they have, I think, different points of view in my observation. But then Assemblymember Jones said he wanted my bill tied to one of his bills. I said, please don't do that. They're going to veto your bill. Oh, no, he said, they're not going to veto my bill. We finally have a clear path in sight. Sure enough, the governor vetoed his bill and then vetoed my bill along with it since it was linked. A gracious gentleman that he was, the following year said, okay, do your thing. I, take you at your word that, you were right, I got vetoed, and let's try it again. So the second year I sent the bill in to Governor Schwarzenegger and had a very good working relationship with the staff. They liked the bill, prepared to recommend the bill. The staff member left 2 weeks before the bill was considered by the governor. New staff member came on, didn't understand the bill. Governor vetoed the bill. Okay, last year, third and final year, we put the bill in. But before I would do such a thing, I asked Mr. Prozio, who was then the legislative director for Governor Schwarzenegger, if he thought it was worth putting the bill in, explaining the history. I said, I don't want to waste your time or ours, sir, or the committee's time for that matter. Is it worth putting in, given this just little comedy of errors? He came back to me and said, yeah, go ahead and put the bill in. I think it looks good this year. Put the bill in. Third veto came down from the governor's office, and when I said, hey, what happened? He said, well, governor's view pretty much was, vetoed it once, vetoed it twice. Why on earth wouldn't I just veto it again? So I have a hat trick of Schwarzenegger vetoes on this bill, largely, I think, for reasons that have nothing to do with the merits of the bill. There is no opposition to the bill. The benefit of having had this conversation with you all now 4 years in a row is that we've worked through all the issues. There is no opposition. It would be helpful when people get the notice to know what is it that's happened to me, how can I defend myself? And it would be helpful for businesses who are obliged to provide the notice to know that if they provide this information, they have complied with state law. It's a safe harbor in effect for them. I would respectfully ask for an aye vote.
The committee just received a late letter of opposition from Governor Schwarzenegger. Besides that, we're okay. First witness in support.
Yes, Lenny Goldberg, Privacy Rights Clearinghouse. We are a small nonprofit, and we try to keep track of the data breaches that occur. We put them on our website. When these data breaches occur, we get overwhelmed with a very small staff by the calls that come in from people saying, what does this mean? What should I do? What happened? How do we respond? And so this bill, which we have supported for all its 4 years and worked on, really is important to let consumers know what's going on out there. I can also say we've talked just to confirm what Senator Simitian said, we've talked with data security experts who have affirmed time and again that California's passage of the bill meant that they were able to do their job, take their do their job much better with those who are holding data, because breach notification is definitely a problem for businesses. I also want to say I was involved in the negotiations with the banks and other businesses that Senator Simitian concluded so well about the content of this notice, that everyone is now signed off and agreed that this form of the bill is one that is acceptable to all parties. So we really urge your support.
Thank you for your testimony. Others in support?
Thank you, Mr. Chair. Members, Pedro Morillas from the California Public Interest Research Group. Along the lines of Governor Schwarzenegger's logic, we've supported this bill for the last 3 years, so might as well make it 4. The biggest reason we support this bill is because the more information that consumers have about what information is out there of theirs, the more tools they have at their disposal to protect themselves. Just a quick example, the remedy for addressing a lost Social Security number is much different than the remedy for losing a credit card number. And if consumers don't know which one is lost, they don't know which direction to take. And so I'll keep it at that and say that 4 years, 4th time is the charm.
Thank you. Others in support?
Valerie Small Navarro with the American Civil Liberties Union in strong support.
Thank you. Others in support?
Ignacio Hernandez on behalf of the Consumer Federation of California. I think this bill gives a new meaning to for the hard way.
Thank you. Others in support or with a sense of humor? Okay. Other those in opposition to the bill? Okay. Seeing none, questions, comments for Mr. Simitian. Bill's been moved. Second. Yes. And seconded?
Second.
Questions, comments? Mr. Weider.
Quick question. Given the political dynamics of this building, do you want Republican support? Encourage the governor a 4th time?
He just added Senator Fuller as a co-author.
Let me I'm going to take just a minute and answer the question with the courtesy of the chair. Yes, sir, I do. The bill is being co-authored by Senator Fuller at my request. We had 8 of the 15 members of the Senate Republican caucus who voted for the bill. There's a lot in this building that requires us to take up sides, draw lines, put it however you will. There are an awful lot of issues where, frankly, partisanship and even ideology have relatively little to do with the content if we could just push all that aside. Privacy is one of those areas. It's one of the reasons I enjoy working in the field. If you have been the victim of a data security breach, you don't care if you are a Democrat or a Republican, if the person who hacked your information is a Democrat or a Republican, or whether the people who voted to give you some protection in the state legislature are Democrats or Republicans. You would just like to think that the body politic could step up and solve a real problem that has grown over the past decade or two, and I would be delighted to have Republican support and include any and all of you who would like to be co-authors, because we do, in fact, have to take amendments today, and I'd be pleased to take co-authors at the time. Thank you.
Thank you, Senator. Other questions or comments for Senator Simitian? Seeing none, I think I'll take that last comment as your close. If I would, let's call the roll.
Fear?
Aye.
Fear, aye. Wagner? Aye. Wagner, aye. Atkins? Atkins, aye. Dickinson? Dickinson, aye. Gaines? Gaines, aye. Huber?
Aye.
Huber, aye. Huffman? Jones?
Aye.
Jones, aye. Monning?
Aye.
Monning, aye. Wachowski?
Aye.
Wachowski, aye.
Congratulations, Senator. The bill is out.
Thank you all very much. Appreciate
Senator
your patience.
Padilla, welcome. Senator Padilla is here on 2 bills, item number 6, SB 332, and item number 7, SB 559. Why don't we proceed to item number 6, SB 332. Senator Padilla, good morning.
Good morning. Thank you, Mr. Chair, members of the committee. I'd like to begin by stating that I, too, would welcome any and all Republican support for the two bills I have before you today, including co-authorship. But on SB 332, let me start by accepting the technical amendments in the analysis as authors' amendments for what's before you. I will try to be brief. This bill would authorize a property owner or landlord to prohibit smoking of tobacco products either in an entire rental property or any part thereof, including individual units. Any such prohibition would be subject to the federal, state, and local laws as they pertain to changes of term of a rental or lease agreement. So we're not going to impinge on any of those. So why am I doing this bill? According to the Center of Disease Control and Prevention, not tobacco use, secondhand smoke is responsible for approximately 50,000 deaths each year in the United States, including 3,400 lung cancer deaths and 46,000 deaths associated with heart disease. California has for many years been a leader on protections in this regard, including the banning of smoking in the workplace, in bars and restaurants, in beaches and parks. There's a little bit of a equity issue in this for me as well. For families in California who are fortunate enough to live in a single-family home, they can make the choice to live in a smoke-free environment or not. For families throughout California who live in multi-unit dwellings, they don't have that option. And in fact, about 30% of California's housing is multi-unit residential, such as apartments and condominiums. And we know that secondhand smoke travels in and out of open windows and doors, through shared ventilation systems, inside walls, through ceiling crawl spaces, gaps around electrical wiring, light fixtures, plumbing, ductwork, etc. So for the interest of those families who could be affected against their will, we want to provide this clarity in law for owners of apartments. This bill is supported and sponsored by the California Apartment Association. But here with me in support today is Jennifer Snyder with the American Diabetes Association and Ryan Spencer of the California Medical Association.
Thank you very much. First witness in support.
Jennifer Snyder on behalf of the American Diabetes Association in support of the bill. We just believe that this is an important bill that both will protect those with diabetes, those at risk of diabetes from being in situations where they have secondhand smoke, allows them to have a choice to be in a rental community that they're not exposed to smoke, and will be helpful and make persons with diabetes a lot more healthy.
Thank you for your testimony. Next witness in support.
Donna Seitz, representing the Los Angeles County Board of Supervisors. We are in support for the reasons stated by Ms. Snyder. Thank you.
Thank you.
Very much.
Others in support.
Mr. Chair, members, Sean Topakian on behalf of the California Apartment Association. Our members represent over 1 million units in the state. I want to echo the Senator's comments in our support and simply say that this measure will give owners more clarity and guidance and encourage them to designate their units smoke-free. Thank you.
Ryan Spencer with the California Medical Association. I'd like to thank the Senator for introducing this common sense measure. The analysis did a very good job explaining the benefits. I did, Ms. Snyder. We ask for your support. Thank you.
Thank you. Others in support of Senator Padilla's measure. Are the witnesses here in opposition to the bill? Seeing none, I do want to say, as a tenant here in Sacramento, having endured secondhand smoke, it is obviously a very significant concern, and I think clarity in the law will be a beneficial thing for everybody concerned. Is there a motion on the bill? Second. It's been moved and seconded. Are there questions or comments, colleagues, for Senator Padilla on the bill? Mr. Wagner.
Let me begin with just a little bit of background. I spent 6 years on the board of directors of the American Lung Association of Orange County, including 2 years as their president, and they are very much an anti-smoking organization. That said, I am concerned that they push, that organization in particular pushes the anti-smoking agenda at the expense of the liberty agenda, and that's what prompts my question. If landlords are already allowed to designate as non-smoking, and they are, and if they're allowed to enforce that in their leases, and they are, what's the point at the end of the day of this legislation? Because what worries me is that it is a step in the direction towards ultimate bans. And a ban of all tobacco products might be for the health, not might be, would be for the health of this state and this country a good thing. But there is still that liberty component that I think we as a legislature ought to be sensitive to. And so that's what troubles me about the bill. Not what you're trying to do, but ultimately where we may go with it.
If I may, Member Wagner, I'll take that as a two-part question. The first part, as it pertains to the Lung Association, to my knowledge, they do not have a position on this bill, nor are they the sponsors of this bill. Second, why the bill? While current state law does not explicitly prohibit landlords or property owners from enacting such smoke-free policies on their properties, nor does it explicitly allow them. And so at the request of apartment owners up and down the state of California, they're seeking the clarity in the law that I believe we're providing through the legislation that's before you today.
Thank you, Senator Padilla. Mr. Wagner, further questions or comments? Are there other questions or comments for the author of the bill? Mr. Wachowski.
I want to be clear on the preemption because there's the grandfather for local ordinances that have it. So the effect would be is that if a local city doesn't have an ordinance and January 1st comes and the apartment owner says, smoker, I want you to get out of you're on a month-to-month, I want you to move out, that furthers the goal of having a smoke-free environment. I assume that I want clarification, that's what's going to happen on January 2nd. In cities that don't have grandfather clause ordinances, right?
Right. In cities or jurisdictions that don't have a law along these lines already in effect, this law would apply. As I mentioned in the opening statement, this bill would not impact in any way existing laws as it pertains to changes to the terms of rental agreements or lease agreements. Now, once a lease is up and there's negotiated changes to the terms, whether it's smoking or not, whether it's pets or not, whether it's anything else, the same mechanisms that protect both landlords and tenants still apply.
So I have a smoker in the unit, and the local law allows for them to remain there on their request. Maybe I'm reading, but the lease expires. I guess it's all up for negotiation, right? It's up to the landlord at that time to negotiate it. Okay, so you don't get any additional time just because you're a tenant. Okay.
Mr. Dickinson, followed by Mr. Monning.
Thank you, Mr. Chairman. I simply wanted to say, Senator Padilla, I appreciate this legislation because here in Sacramento County over the last several years, we've worked quite cooperatively with our local apartment association on a voluntary program to limit smoking in apartment units, and we hadn't taken formal action on ordinances as far as the county is concerned. But I think there's always some reluctance on the part of landlords and apartment owners to push that as far as they might prefer to, in terms of making sure that their tenants are protected from secondhand smoke. It seems to me that this legislation will give them a basis for saying state law permits me to do this and to make sure that the health of my tenants are protected. So I still see it as fitting the voluntary model largely of letting landlords and tenants decide for themselves ultimately what the character of that tenancy will be, but this is an important and helpful tool in getting to a more smoke-free environment. So thank you for the legislation.
Thank you, Member. And just to underscore the point, particularly to our Republican colleagues here, this is not a mandate. This is not a ban on smoking in rental units. It simply affords property owners the option, the choice. They might take it, they might not. But those who choose to will have the clarity in the law should they choose to.
Thank you, Senator Padilla. Any further questions or comments for the Senator? Seeing none, do you wish to close?
I would respectfully ask for a vote.
Call the roll, please.
Fear?
Aye.
Fear, aye. Wagner? No. Wagner, no. Adkins? Adkins, aye. Dickinson? Dickinson, aye. Gaines? Gaines, aye. Huber?
Aye.
Huber, I. Huffman. Jones. No. Jones, no. Monning. Wykowski.
Aye.
Wykowski, aye.
That bill is out. Congratulations, Senator. Now we'll proceed to item number 7, SB 559. Please.
Thank you, Mr. Chair. Let me also begin by accepting as authors' amendments those noted in the analysis, which specifically would add the term genetic information to Government Code 11135. Also, since we're taking amendments, understand that Assemblywoman Atkins wants to sign on as a co-author to this bill, and I gladly welcome her support and involvement here. This bill, SB 559, would add genetic information to the existing list of protected classes in California laws that are in the Unruh Civil Rights Act, as well as the California Fair Employment and Housing Act. As many of us are increasingly aware, genetic testing can allow individuals to take steps to reduce the likelihood that they will contract a particular disorder. New knowledge about genetics may also allow for the development of better therapies or treatments that are more effective against disease or have fewer side effects than current treatments. These rapid advances promise significant medical progress while also giving rise, unfortunately, to the potential misuse of genetic information to discriminate. I'll forego for now the long history of such discrimination in the state of California or across this country, but suffice it to say that there is such tragic history that we seek to avoid going forward. But why the urgency for the bill? Automation is exponentially increasing the speed and efficiency of a complete genomic DNA sequence. What used to take 5 years to complete not too long ago can now be completed in a matter of minutes. And genomic sequencing is fast approaching the point where it will be widely available and affordable to the general public and potentially a covered insurance benefit. And while genes are neutral markers, many genetic conditions and disorders are associated with particular racial and ethnic groups, and members of those groups may be stigmatized or discriminated against as a result of genetic information being inadvertently shared. I'll just give one example, an example of genetic discrimination in the workplace. In Lawrence Berkeley Laboratory, once upon a time, there was a use of pre-employment genetic screening, which led to a lawsuit, which led to a court decision in favor of the employees. The state of California, I want to underscore, has a compelling public interest in realizing the medical promise of genomics, but we have an equally compelling public interest in relieving the fear of discrimination and prohibiting its actual practice. There is federal law that has been passed in this arena. In 2008, the Genetic Information and Non-Discrimination Act, that's referenced in the analysis, but the scope of that Non-Discrimination Act is limited to health coverage, health insurance. I believe California's overall policies on protections and non-discrimination are much wider. Fair employment, housing, public accommodations, other areas. That's the areas that this bill would, in addition, cover. I want to thank you for your time this morning and introduce Mario Guerrero on behalf of Equality California here in support of the bill.
Thank you very much, Senator. Your first witness in support.
Mr. Chair, members of the committee, Mario Guerrero with Equality California. We thank the Senator for introducing this bill, and we're gladly here in support and urge your aye vote. Thank you.
Thank you. Others in support?
Mr. Chairman and members of the committee, Lee Sandall with the International Longshore and Warehouse Union, and we are in support.
Thank you. Senator, I think you've gathered the most eclectic array of supporters we've seen for a while here. Is there any
That's what I do.
Yeah, very good. Is there any opposition to the bill? Witnesses here in opposition? Seeing none. Colleagues, questions or comments? Mr. Wagner.
Thank you, Mr. Chairman. Quick question, Senator. Genetic information, does it matter how the genetic information is obtained? Let me give you an example. If I'm, a common carrier, a trucking company, and I want to make sure my drivers can see all the signs on the road and, are not colorblind, I can get genetic information, or I can just, do a color blindness test. Color blindness is carried on, I think it comes on one of the X chromosomes, but I don't know the science behind it. It's genetic. Does your bill cover that? If I get it tested one way but not the other way? Does it cover it in both cases? How does it apply?
Yes, it's inclusive of how it's collected, but the bill speaks to not how it's collected, but more how it's used to discriminate. Clearly, your example of a truck driver, if there's something, regardless of how the information is collected, that will lead an employer to determine, well, for safety reasons, there is a consideration to hire or not hire, or promote or not promote, or classify, reclassify a job or specific position, then there's safety reasons for doing that, but not sheer discrimination based on genetic information.
Who gets to make the determination whether there's a safety consideration? Can he not still
Existing
sue?
California law.
Ms. Ryder, any further questions? Thank you. Colleagues, Ms. Atkins.
Thank you, Mr. Chairman. I would just say thank you for this legislation. I would love to be a co-author, as you indicated, and I would move the bill.
Thank you. The bill's been moved.
Second.
And seconded. Colleagues, further questions for Senator Padilla? Questions or comments? Seeing none, Senator, wish to close.
Respectfully ask for your aye vote.
Thank you very much. Call the roll.
Deere.
Aye.
Deere, aye. Wagner. Wagner, no. Atkins. Atkins, aye. Dickinson.
Aye.
Dickinson, aye. Gaines. Gaines, no. Huber.
Aye.
Huber, aye. Huffman. Jones. Jones, no. Monning. Wykowski.
Aye.
Wykowski, aye.
That bill has 5 votes and is on call, requires 1 more.
Thank you very much.
Thank you, Ray. Okay. Now, we have Senator Keogh, who is here on item number 5, SB 328, regarding eminent domain.
Thank you, Mr. Chairman.
Senator, good morning.
Good morning to you also and members. Thank you for allowing me to present this bill, just in case I have to make any corrections.
Good.
This is SB 328, and it deals with how conservation easement holders and public funders are treated in eminent domain proceedings. Members, it's only about eminent domain. Conservation easements are used to protect a wide variety of natural and cultural resources in California. They're often paid for with public funds as a way of protecting that land in perpetuity. Yet there's little or no ability for those who hold conservation easements to participate in eminent domain proceedings should they occur. Easement holders report that they are often overlooked in the process. By the time they are able to participate, it's often too late for them to be constructive participants. Even public agencies that provide public funds to acquire easements usually have no role or rights in the process. This bill lays out a clear process in statute for reasonable notice and an opportunity for both the easement holder and the public funder, if there is one, to be heard in the proceedings. The bill does not limit or expand eminent domain in any way. It will ensure that public benefit and financial investments in protecting these easements is not lost, and it still allows eminent domain proceedings to occur as they are currently provided for in statute. It's sponsored by the California Council of Land Trusts. It's supported by the San Diego County Water Authority, the Association of California Water Agencies, Metropolitan in Los Angeles, the Trust for Public Lands, and many others. There is no opposition. With me is Darla Ginsler, Executive Director of the California Council of Land Trusts. She can answer questions and has been most helpful in developing this bill.
Thank you very much. Senator, your first witness in support.
Good morning, Mr. Chairman and members of the committee. My name is Darla Ginsler. I'm the director of the California Council of Land Trusts, which is an association that works on behalf of 150 nonprofits around the state. In 2009, we worked with eminent domain attorneys from the water sector, transportation, and many others to carefully craft a bill that would detail the process for how a property that has a conservation easement on it would be condemned, and it embeds this process within the state's eminent domain statute so that everything an agency needs to know is in one place. And by providing early notice and an opportunity to be heard, the easement holder and public funder has an opportunity to participate early in a constructive way as opposed to being the last in the line to receive notice. As Senator Kehoe mentioned, we've had broad support for this bill, and we have no opposition. We think that this bill does elucidate the rules of the road so that it hopefully, when we do need to condemn properties with a conservation easement, it's done as efficiently and effectively as possible. We thank Senator Kehoe and her staff and all the supporters for working with us so hard on this bill and urge your aye vote. Thank you.
Thank you very much. Others in support?
Erin Gilbert with the San Diego County Water Authority in support.
Thank you. Next witness in support?
Rosie Thompson with the Metropolitan Water District of Southern California in support.
Thank you. Others in support of Senator Keogh's measure? Are the witnesses here in opposition to the bill? Seeing none, colleagues, questions or comments for Senator Keogh? Mr. Jones.
Good morning, Senator. I'm kind of struggling with this, kind of being on both sides of the issue from from the city council side, having to use eminent domain for public projects, and also being a commercial real estate agent on the private ownership side of the issue. So some concerns I have in moving down the process of condemnation of an agency taking a piece of property. Timing is a big deal, and usually a lot of talk in the negotiations. So one concern I have is when these easements are on these property, when will they be? Is your bill requiring them to be notified at the same time that the property owner is being notified of the easement, of the condemnation process? That's number one. And then number two, is there a limit on the timing that the conservation easement can enact action against the condemnation, so that they're not waiting till the very last minute when there's already a deal negotiated between the two parties that they'll be able to upset? And then I have one more question after that.
Thank you, Mr. Jones. I'll let Ms. Ginsler answer.
Thank you.
Yes, the easement holder is notified at the same time that the property owner is, right at the beginning of the process. And then to your second question, yes, there's a whole, the bill lays out a whole process of timing by which, if the easement holder does not object or, provide information saying they want to participate in hearings, attend hearings and testify and so forth, that then they don't have those rights to do so.
So at some point in time in the process, if they don't take a positive action, then they're eliminated from the process.
That is correct.
Can you outline that for me? Can you tell me what that is in the bill language?
What the
timing is?
What the time? What the timing
the timing is? It's laid out. It starts the notice is 105 days before the authorized entity, the governing body, would be able to it's going to make a decision about condemning the property, and then they have 45 days in which the easement holder has to notify both the public funder as well as the or notify the public funder, and then provide feedback to the agency about any objections or concerns they have. They have to, within that 45 days, also express their intention to attend the hearing that the public agency would hold. And if they don't give notice that they intend to attend and testify at that hearing, then they're unable to attend that notice of resolution of necessity hearing and testify. And so this early notice does have a whole set of processes or timelines that spelled out for their participation.
So if they don't act,
Mr. Jones, that starts on page 3, line 33, section C, and really steps through it just as Ms. Ginsler described, if you want to see it in the bill language.
Thank you very much. And then, so the bottom line is, if they don't act within 45 days, then they're eliminated from the process. Is that correct?
Well, they're eliminated from that early notice, just like any property holder. As the condemnation proceeds, the easement holder does, at the very end of the process, when it goes to court for a final decision, also has a right, just like a landowner, to object. But they have that under existing law. So this bill is really puts the boundaries around what that early notice and early participation would allow.
Okay, so, and then, moving down the timeline towards the end, and we've got a transaction being negotiated between the agency taking the property and the landowner, and they've come to deal points that they agree on. What does this bill do to give the easement holder additional rights to add on or negate or veto that negotiated transaction?
There are no additional rights in the bill, Mr. Jones. We don't change the eminent domain process at all. This is about that early notice aspect of it. And it's not exclusive to public agencies, but you did hear the testimony from the County Water Authority, the Metropolitan Water in Los Angeles, and others. So these would be, for the most part, public agencies getting earlier notice and hopefully resolving lack of communication or information earlier on, avoiding problems towards the end.
Okay, and then one more last question on regarding mitigation land. Sometimes these conservation easements are mitigation for other projects. So, if we're taking that mitigation land and doing something else with it, how does that play into this?
Well, under existing law, a conservation easement is a recognized property interest and a compensable right of property interest under the existing eminent domain statute. So if property that has served as mitigation for something else is condemned and that conservation easement has to be compensated, and then that party would use, like say a land trust or an agency would use that the proceeds from the loss of that easement that was done for mitigation to acquire something else similar to it.
So this law or current law already requires them to take those funds and purchase other mitigation land, or they can use those. What happens if they don't find land that they want to purchase?
Let me just. We're not requiring any funding mechanism here at all. We are working within eminent domain proceedings as they're already described in statute, only requiring early notice to easement holders. Whatever is in state law regarding mitigation for real property, that is not addressed in this bill, only the requirement for the early notice.
Okay.
So I don't want you to think it's broader than it is.
Okay, I appreciate that. Yeah, I appreciate that. And as you can tell, I've started, coming up with all kinds of scenarios where this could go bad. So.
Right, but think of it, Mr. Jones, I'd encourage you to think of it as if you are the easement holder for a San Diego County water pipeline from one of the reservoirs into the public system, that easement is held by a public agency for public infrastructure, and we want to be sure that if any other project is coming up, redevelopment, school construction, highway, or whatever, that agency gets adequate notice at the start of the process.
Okay. Well, I'm going to support the bill for today.
Thank you.
And I think you've answered my concerns. Thank you.
Thank you, Mr. Jones. Other questions, Mr. Dickinson?
Thank you, Mr. Chairman. I just wanted to confirm what I think is the case with respect to this legislation, that the failure to take advantage of the opportunity to appear when the resolution of necessity is being heard would not give rise to the opportunity of the condemning entity in the condemnation action to raise a failure to exhaust administrative remedies. And I take it that argument would not be available by virtue of what's in the bill granting the right of the conservation easement holder to, first of all, requiring that they be named as a defendant, and secondly, that they may appear in the proceedings.
The resolution of necessity hearing already has a requirement that a party has to request the opportunity to participate in that hearing. And so if under this bill the easement holder and the public funder of the easement does not request the right to appear at that hearing, they do lose the ability to do so, but that's the existing practice, as the eminent domain attorneys have told us. Otherwise, other than that resolution of necessity hearing, all other existing rights would continue.
Right. A property owner doesn't always appear at
That's right.
RON hearing. They still can defend, but I just want to make sure that we don't run into any difficulty by virtue of this bill. Okay. Thank you.
Thank you, Mr. Dickinson. Other questions or comments for Senator Keogh? Seeing none, Senator, do you wish to close?
I ask for your aye vote.
Okay. The bill's been moved and seconded. Call the roll, please.
Fear?
Aye.
Fear, aye. Wagner? Wagner, aye. Adkins? Adkins, aye. Dickinson? Dickinson, aye. Gaines? Gaines, aye. Huber?
Aye.
Huber, aye. Huffman? Huffman, aye. Jones? Jones, aye. Monning? Wachowski? Aye. Wachowski, aye.
It's a landslide, Senator Keogh. Congratulations.
Thank you, Mr. Chairman. Thank you, members. Appreciate it.
Thank you. Senator Yee is here for our final bill, SB 111, item number 2 on our agenda. Senator Yee, good morning.
Thank you very much, Mr. Chair. This bill came about in 2008, where the Ladies Professional Golf Association announced that its policy moving forward would be that all players needed to learn English and be proficient in that language as a condition of participating in their golf tournament. And as you can imagine, people were rather surprised, and some others were shocked about what was the correlation between speaking English and playing golf well. And probably the answer for all of us is absolutely nothing. And so with a lot of advocacy on the part of a lot of organizations, both California and national organizations, we were able to put an end to that particular policy. This bill just simply codifies that particular practice of not having businesses require English as a condition of patronizing any particular business. In response to, I think, being sensitive to the business community, we made it very, very clear in this particular bill that unless you show some kind of business necessity, you cannot then comply. And then my staff, working with your staff, we've also, and we will take as author amendments, some additional language that clearly indicates that particular position. I believe, now I'm not sure, but maybe the California Chamber will come up and say that they've removed their opposition and stay neutral on this particular bill. And with that, urge an aye vote.
Thank you, Senator. You're taking all the author's amendments that are listed on page 6 of the analysis. Is
That's
that correct?
correct.
Thank you very much. Your first witness in support, please.
Hi, good afternoon, Chair and members of the committee. My name is Jeanette Snipatin. I am the legislative staff attorney with the Mexican American Legal Defense and Educational Fund, and I am here in strong support of SB 111. I am pleased to speak that Senator Yee has been able to work out these amendments. We are definitely all supportive of the amendments as they do clarify some of the issues that were raised by the Chamber of Commerce and also directly address the issues that were raised in the governor's veto message of a prior version of this bill. So we feel that the amendments, take care of those two issues that were previously raised. MALDIF is one of the nation's leading legal Latino organizations, and we promote social change through advocacy. With over our 40-year history, we have made significant contributions to securing the rights of Latinos in various areas here in California and also at the federal level. We think that SB 111 is a straightforward measure and very simple in terms of that it does not impose additional requirements on employers, but rather clarifies that if an employer were to adopt a policy, that it would have to fulfill the requirement as a business necessity, and we feel that is consistent with FIHA as well, because it would require that if a policy were to be adopted in a language other than English, the employer would have to not only give notice to the employees of that policy, but also provide employees with the consequences of such policy. And for those reasons, we are in strong support of the bill. Thank you.
Thank you for your testimony. Next witness in support, please.
Good morning, Mr. Chair and members of the committee. I'm Santosh Siram Santana with Asian Americans for Civil Rights and Equality, and we're in support of the bill. Thank you.
Thank you. Others in support?
Good morning, Chairman of the committee and members of the committee. My name is Ronald Coleman with the California Immigrant Policy Center, also here in support.
Doing a little remodeling here. Good morning, Mr. Chair. I'm Lynn Fawkes on behalf of the California Federation of Teachers. We ask for your aye vote.
Rebecca Gonzalez on behalf of the National Association of Social Workers California chapter in support.
Valerie Small-Navarro with the American Civil Liberties Union, also in strong support.
Thank you. Are there other witnesses here in support of the bill? Seeing none, are there witnesses here in opposition to the bill?
Here we go. Thank you, Mr. Chair and members. Mira Gerten here on behalf of the California Chamber of Commerce. I am still in opposition today, and I think we're about 95% of the way there. I thought we had all of the amendments that are in here were sent to us on Friday, and I initially gave it the thumbs up, and then over the weekend I heard back from a couple people with concerns basically over one word. So 95% of the way there. We just didn't have a chance to kind of run that concern past all of the supporters and the senator. But we we, are very grateful for all of the work that your staff and that the Senator's office has done to help address our concerns. I think Section C in particular has done a lot to clarify what it is that is being asked of employers and what is not being asked, so that we can comply with the law and not end up having to have it enforced through litigation, because what our employers ultimately want is to comply with the law. So we don't have any concerns with the bill moving forward today. I think we're basically within a day of getting everybody on board, and I kind of say that on behalf of all of the other people as well who I've been negotiating for.
Do you want to share with us the word?
Yes, absolutely. So in Section C, they have added an independent duty, and I think the goal of that phrase is the same goal as the second sentence, however, nothing in this section shall be construed. So the goal is to preserve existing law and make sure that that anything that we've done to kind of clarify you don't have to communicate, negotiate, and contract with your customers doesn't then negate other portions. For example, Section 1632 in the Civil Code. We're fine with making sure that those things are protected, but we think that using the term independent in front of duty is a little confusing and maybe creates some confusion about that sentence, which is the part that's really protecting the employer. So we were hoping to have it struck or come up with an alternative way of making sure that we're protecting those other statutes.
Yeah, I think the purpose of the word independent is to clarify that the statute in and of itself is not adding a new duty to that which previously exists.
Yes.
I'm actually, as an attorney, struck by it's not clear to me how the word independent in any manner creates confusion. I think it actually clarifies the statute rather well. Do you want to share anything further about that critique, or is that as far as you're ready to go today?
I think that's about, our feeling is that because it's duplicative, if that's the purpose, it's duplicative of the second sentence, that it kind of causes everyone to say, well, then is that what it means? So that's what it's caused a lot of my members to think. I certainly see the other side of it. I know I've had conversations with their staff about it, but all I know is for today, I do not have an answer of what happens to everybody's position if the word stays in. We just didn't know what the outcome would be.
But the point is that the senator is very close
Yes.
to having achieved what he was hoping to, which is a collaborative
Yes.
approach to this legislation rather than a contentious one.
Yeah, and this version of the language is significantly better. We're very happy with where the bill is going, and we hope we can address that. If it's not addressed, I just don't know what the final answer is, but we're very pleased. Thank you.
All right.
Julie Broyles here on behalf of the Associated Builders and Contractors of California. Remember the coalition and agree with the points made by the Chamber and appreciate the movement by Senator Yee and the sponsors. Thank you.
Okay. All right. Questions or comments from members of the committee for Senator Yee? Mr. Wagner.
Thank you, Mr. Chairman. And two quick questions or comments. My concern about this bill is that it may well be an example of bad facts making bad law. I mean, the fact that the LPGA decides that all of its golfers ought speak English is, as you correctly note, Senator, sort of strange. But the flip side of that is, they've got the LPGA. It's their call, not necessarily ours. And if they think they want to have their golfers communicate better than they might otherwise be able to, what business really is that of us, or what business is that of the legislature to get involved in the individual business decisions of any private entity? If they want to enforce one particular rule and it helps them or it hurts them, that's their call. And it strikes me as perhaps not our role to micromanage. Especially, I question whether maybe we even have the legal right under the state constitution to get involved at that level. The state constitution says the legislature and officials of the state of California shall take all steps necessary to ensure that the role of English, blah, 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 is preserved and enhanced. Moreover, the Constitution gives a private right of action to anyone who feels that the legislature and or any business is not complying with that particular section of the Constitution. So, we may not like that language in the Constitution, but all of us took an oath to uphold it. Is this law consistent with our duty under the California Constitution, and is it right for us to meddle in the internal affairs of every private business in the state of California?
Mr. Chair, I will try to be very, very short in a response, and maybe some of my supporters might want to just chime in. I think all of us want to be very, very supportive of businesses. They are an important body within the life of this great state. But with that said, if there are things that happen in a particular business that clearly are unfair, discriminatory, we ought to say something about it. Just as we don't allow anyone to conduct their business in the state of California that cheats people. I mean, they do that. A business may do that. Based on your rationale, then maybe we should just leave it alone. But I think there's something about the state that should, in fact, stand in there and say, we've got to be fair and we've got to somehow ensure that things are conducted appropriately. And in this particular case, a company came in to the state of California and said, if you don't speak English, then you can't play. Even though you are a great player, but you can't play. And that's all this bill does. And I think we have gone through extraordinary lengths to assure businesses in California right now that nothing in this particular bill would in fact prevent them from conducting their business as usual, so long as they don't somehow discriminate based on language. And the reference that you made in the California Constitution, and I think that's the Proposition 63, and even in Proposition 63, if you read the ballot argument, they made it very, very clear. Then I state, nothing in the amendments prohibits the use of language other than English in unofficial situations such as family communication, religious ceremonies, or private business. And so that's what this bill tries to do, sir.
Okay, well, let me first of all, the idea that anything I said about allowing business to make business decisions as to things like what language would be used and what they think their customers would want has absolutely nothing to do with saying in the same breath, okay, and we'll also let you cheat your customers if you want. There are laws against those sorts of things, and they're in no way implicated either by this bill, I recognize, or by my question. So I frankly don't understand that part of the argument. We are allowed to say to businesses, you will not cheat. You will not discriminate based on race. You will not discriminate based on immutable characteristics. That is a far cry and something very different from what this bill is attempting to do. And I understand what the ballot arguments said, and it seems to me that you are going the other direction. The legislature is, in fact, prohibiting businesses from taking steps that are, that frankly would be consistent with the Constitution. And I just don't think the legislature should be forcing businesses to take steps, and in passing our own laws, taking steps that are inconsistent with what the public said we should do in Proposition 63, what the public has said we should do in Article 3, Section 6. We may not like it. We might have voted against that proposition, but it's there. It's in the law. And we ignore it in a way, if we ignore it, we are acting, I believe, in a way inconsistent with our oath. And I haven't heard a response to that.
I'm happy to take a shot at that myself. I think Mr. Monti may want to as well. Senator, with your leave, I would turn, I think Mr. Monti wishes to respond, and depending upon his response, I have a couple of responses as well, and then I'll return to you, Senator. Please, Mr. Monti.
Well, thank you, Mr. Chair, and I want to thank the Senator for bringing this forth. Some may suggest is this really necessary because we protect language rights in the workplace consistent with the employer's need to rely upon a particular primary language to get the job done. But if we look at some of the history of the evolution of language that Assemblymember Wagner cited in some of our more recent history, the Treaty of Guadalupe Hidalgo was negotiated and written in Spanish and English, which created the groundwork for the independence of Alta California that led to our first state constitution in Monterey being drafted in 1849. But that treaty document identified the language of the state as bilingual. that's ancient history at this point. But fast forwarding to current history and some of the evolution of the law in the civil rights and employment area, I think this builds upon and fortifies that already established legal foundation. In my prior life as a litigator, I represented 2 employees who were terminated from Taco Bell for speaking Spanish. Now, that sounds rather interesting because in the deposition, we tried to determine how they could fulfill an order for a burrito, and would they have to say, "Here's your little donkeys." We prevailed in that case. We won those workers' reinstatement for not only being able to converse on their own time in a native language, but also being able to enhance the customer service because of their bilingual capacity. Again, I realize this bill doesn't go specifically to the employment arena, but it builds upon that foundation. And I think it puts on the record California that those who want to do commerce and business in California, even in entertainment or sports, are going to respect native language capacity, national origin of those who we invite to our great state. So again, not really a question, more of a commentary, but I do want to thank the author for bringing this forward, and I'm looking forward to the chair's observations on this as well.
I was only going to respond to Mr. Wagner's important questions by saying that there is Ninth Circuit precedent that speaks to the questions that Mr. Wagner has raised. And in one particular case, a panel observed that Prop 63 was essentially symbolic in nature, and notwithstanding its symbolic nature, nonetheless is focused on official governmental communications. And I think that's really the core point, is that if one wants to raise Prop 63 as a bar to this legislation, the response is, among other things, that Prop 63 was addressed to governmental communications as opposed to private communications, at least as interpreted by the Circuit Court of Appeals for the state of, for this region, which includes California. So having said that, other questions or comments for Mr. Yee? Seeing none, Senator, do you wish to close?
Just that we have really gone through extraordinary length working with the business community to ensure that they don't see this bill as an additional burden on them. And with that, urge an aye vote.
Thank you. Is there a motion on the bill? Is there a second? It's been moved and second. And call the roll, please.
Fear.
Aye.
Fear, aye. Wagner. Wagner, no. Adkins. Adkins, aye. Dickinson. Dickinson, aye. Gaines. Gaines, no. Huber. Huffman. Huffman, aye. Jones. Jones, no. Monning.
Aye.
Monning, aye. Wachowski.
That bill has 5 votes and is on call. Thank you, Senator.
Thank you very much.
Okay, so now we will proceed to lift the call. We have 3 matters on call, and I think 2 of them we can resolve at this point. Item number 3, SB 154 by Senator Woke. The vote is 5-4 with the chair voting aye. Call the absent members, please.
Huffman, aye.
That bill has 6 votes and is out. SB 559 by Senator Padilla, item number 7 on our agenda. The vote is currently 5-3, chair voting aye. All the absent members, please.
Huffman. Huffman, aye. Monning. Monning, aye.
Okay, that bill is out. And what remains is SB 111 by Senator Yee. And I think we need to have Mr. Wachowski, who is presenting a bill in another committee, return. I will not, the bill has 5 votes. I don't think anybody needs to add on. Members, if you'd like, you can feel free to leave. I will remain for Mr. Wachowski. Thank you for your attendance today.
Yes, and I'm